Okay, welcome back. In this video, we're going to talk about responding to a petition to modify and or enforce. And again, the post-decree procedures are different. Pre-decree, pre-order, the response is pretty important. I mean, if you don't respond, you could go into default, all this stuff. Here, the response is optional post-decree. So the procedures are quite different here. So the opposing party is not required to file a response. This is under Rule 91L. Unless a statute or rule requires otherwise, a party served with a petition may, but is not required to file a response to the petition. If, however, you're going to respond, then you need to file and provide a copy of the response to the other side. And your response must be filed at least 3 days. That's going to be 3 business days before the scheduled conference or hearing. So you've got to, if you're going to do it, there is a deadline. Now, in your response, or even prior to filing your response, you can raise certain defenses. Not every defense is going to apply, but you can raise these defenses, which is lack of subject matter jurisdiction. So saying this court doesn't have jurisdiction over this subject matter, so over modifying the underlying order or enforcing it. A lack of personal jurisdiction over one or both of the parties, if venue is improper, if service of process was not done correctly, or if there's been a failure to state a claim upon which relief can be granted. Now, again, we have a different procedure post-decree. Generally, these types of defenses must be raised before filing a response if one is required. However, a motion for lack of subject matter jurisdiction could be made at any time. Now, if a pleading sets out a claim for relief that does not require a responsive pleading, the opposing party may assert at trial any defense to that claim. So in this post-decree arena, you could raise these defenses at any time. So the timing is different. Okay. All right. Now we had a question about what rule says the 3 days. That's Rule 91L. So the response must be filed at least 3 days before the scheduled conference or hearing. And then 3, if you have days that are less than 11 days, you count only business days. So 3 days is going to be only business days. Okay, so we went through the defenses. All right, here's the forms to draft an e-file if you're going to do a response. So you've got your cover sheet, your sensitive data form, your response, and then if you're responding to a petition to modify child support and or spousal maintenance, or you or your opposing party are requesting an award of attorney's fees and costs, then you've got to do that affidavit of financial information, and that's due 20 days after service. All right, let's look at a response to a petition to modify legal decision-making, parenting time, and child support. Now, as I showed in the first video, there's various types of petitions to modify or enforce that could be filed. So we're just going to look at this one type of petition, which is a petition to modify legal decision-making, parenting time, and child support. And I'm going to show you how to respond to it, because what I found is that there are no set court forms for a response. Okay, we have a set court form for the petition, but the court websites don't have a set response form. And so I'm going to show you how to do a response. And this form that I created for you is going to be in the materials below the video. So everything in red, that's going to be all the parts that you need to fill out and complete. So the caption, the county you're in, each party's name, your case number, and then whichever party is the responding party, it could be the petitioner or the respondent. So whichever party you are, if you're responding, update this to name whatever party you are, and then explains that you are responding to the petition. So how this works when you're doing a response is your paragraphs are going to match up to the paragraphs in the petition. So when this says, one, admit, this is matching up to paragraph 1 here and saying what was put in paragraph 1 in the petition. Of course, this is a blank one. This would be filled out in your case. You're saying that's true. I admit it. Now, let's say here there's information about the parties, and let's say the address is not correct here in number 2. So that's where you could say admit in part and deny in part. Respondent's current address is, and then put what the correct address is. The remainder of the paragraph is admitted. So that's one way to draft a response to a paragraph where you agree with part of it, but part of it you disagree with. Now, let's go to page 2 of the petition. Here's paragraph 3. So information about the children, if that was all correct, admit. If this paragraph 4 about the affidavit regarding minor children, if you agree with that, you can admit. Now here's paragraph 5, information about the order that they want to change. So the order was issued on, the order was issued by the county, the state, and each of the following is true. List that. The order I wish to change is on page of the order, what the order now says. So I put here, this paragraph does not require a response. Now, again, this is in red, so you're going to need to tailor this to your particular case. Now, if everything about the underlying order was true, you could admit that. But this part about the order I wish to change is on, this part of the order identified above, like that's just, it doesn't really require a response. They're just asserting what their position is. So, you can admit this if it's true as far as the underlying order, or you can deny it if they haven't quoted the underlying order appropriately. And you can make a distinction saying, the part that they want to change, that doesn't require a response. Then we have paragraph 6 about domestic violence. You'd see what the petition says, either admit or deny it. Paragraph 7, why the decree or order should be changed. These are my reasons why I believe it should be changed. Now here I put deny. So they're putting their reasons why the order should be changed. If you disagree and you don't want the order changed at all, then you can deny their basis for requesting to change the underlying order. Then we get into the request that the petitioner is asking the court to make. And so you'll see that I typed this up so it matches parenting time, paragraph A. And here I just wrote, you'll need to update this so that all the parties referenced are correct, but that the opposing party's request to modify parenting time be denied. So here is just asking that for a straight up denial of all requests made by the other side. But if you're in agreement with their parenting time request or their child support request, you can put admitted, you don't, or, be granted. So you're going to need to tailor this to what you're specifically requesting and then fill out the rest of the document properly. Okay. So this is just, B, C, D going through the rest of the requested relief. And then the final page of the petition, again, just showing you how the paragraphs match up. That's how you do a response. Now, if you are the petitioning party and the other side files a response, what do you do with their response? You read it. And as you're reading it, you want to identify what is in dispute and what is not. From there, you can start working on your Rule 49 disclosure statement. You can start working on your proposed resolution statement. You can make a settlement offer if you're in a position to do so. And then from here, let's talk about the next steps. So the petition was filed. The order to appear was issued. The petition, the related documents, the order to appear, all of that was properly served. And a proper proof of service was filed. Maybe a response was filed, maybe not. What happens next? Well, if your case is set for a resolution management conference, then you'll want to prepare for the resolution management conference. So a resolution management conference is what it sounds like. It's a conference where the parties meet with the judge in order to manage resolving the case. So no evidence is taken, no witnesses are presented, no exhibits are admitted. It's just the parties and the judge talking about what's the current case status and where are we going next? Do you want to go to mediation? Do you want to try a judicial settlement conference? Do we need to set a trial date? All of that is discussed at a resolution management conference. Now, in order to prepare for the RMC, there's certain things that you're supposed to do. And those things you're supposed to do are supposed to be done 5 business days prior to the RMC. So 5 days prior to the RMC, you're supposed to complete your initial disclosure statement and provide it to the other side. Keep in mind, disclosure statements do not get filed with the court. They only get exchanged between the parties. So for the Rule 49 disclosure, you just send it to the other party and you don't have to do anything else with it. Also, there's a form called proposed resolution statement. You'll need to draft that and e-file it at least 5 business days prior to your RMC, and you would provide a copy to the opposing party. And then at least 5 business days prior to your RMC, you'll need to have a meet and confer call with your opposing party or his or her lawyer to try to resolve as many issues as possible. Then you'll attend the RMC. You'll work with the court and your opposing party to set a date for an evidentiary hearing or a trial. It's the same thing. I called it both just because you'll hear both words. You can be clear it's the same thing. And that final trial would be on all unresolved disputed issues. Now, if your case is set for an evidentiary hearing, then you need to prepare for the evidentiary hearing. So calendar your hearing date, calendar your exhibit deadline, draft your list of witnesses and exhibits, notify your witnesses of the hearing date, time, and location, and confirm they will appear in court as soon as possible. Disclose all exhibits you intend to use at the hearing that you've not previously disclosed. Same thing with witnesses and exhibits. Draft your hearing trial outline, same thing. So start drafting your questions, your script for the trial. Okay. So with that, I'm going to stop this recording. That covers responding to a post-degree or post-order petition to modify or enforce, the next steps from there. And in this final video, I'm going to give a summary of everything we've talked about in this series.